Part 2. Firing.
Chapter 6. Common questions about the performance management and termination process. 61. What is progressive discipline?
You can't attempt to understand the firing process without studying progressive discipline. Progressive discipline is a series of attempts that employers make to turn around poor-performing employees via verbal and written performance warnings. When these warnings are violated, then companies terminate employees for cause. Progressive discipline is therefore the precursor to termination for cause. The logic to these documented warnings is threefold. First, employees should have the right to learn about performance problems before they are terminated so that they can improve and ultimately have a fighting chance at keeping their jobs. Second, should your company be sued by an ex-employee for wrongful discharge, see question 69, you could defend your company's actions by demonstrating that you acted responsibly as an employer in letting that individual go. Third, if you can turn around a poor performer, you not only get a valuable one but also spare yourself the headache and money of replacing that employee. Progressive discipline ensures that your company acts reasonably and documents the effect of the worker's unwillingness or inability to do his job. Later, if you're sued, you can prove that, despite your interventions to better the situation, you ultimately were left with no choice but to terminate that substandard performer. In addition, you acted reasonably and responsibly by documenting your affirmative efforts at helping to rehabilitate your worker. You also can prove the employee realized that his job was in danger of being lost. Each attempt to document the ongoing performance problems adds a more serious element to the process. Consequences such as suspension, probation, and ultimately termination step up the severity of failure to improve. Therefore, a plaintiff attorney would have difficulty asserting that her client, your ex-employee, was denied workplace due process. Tell me more. Workplace due process comes from a legal theory known as the job as property doctrine. This theory asserts that the right to work is so intrinsic to American citizens that work should not be denied arbitrarily or capriciously, without just cause as accorded under the 14th Amendment to the Constitution. The way employers accord due process in the workplace is via a series of written performance warnings in the progressive discipline process. This fundamental expectation of fairness is alive and well today in courtrooms and arbitrators' chambers. Although the concept of employment at will severely restricted the job as property doctrine when employment at will was born in the 1930s, today employment at will has been severely restricted in its use. Now, when wrongful termination claims are not dismissed via summary judgment and end up going before a court, companies must show that they had cause to dismiss a worker. Failure to demonstrate cause may result in a court or arbitrator mitigating your decision to terminate to a lesser penalty, for example, reinstatement plus an unpaid suspension, for example,